Hello, I'm Shania Therese S. Villanueva, and today we're examining GR number 247348, decided November 16 of 2021, Christian Cadajas, Ikabyas versus the people of the Philippines. Before we begin, a brief content warning. This case involves child sexual exploitation, explicit online communication between an adult and a minor, and themes of grooming. While I'll discuss this professionally and objectively, the subject matter is sensitive. This Supreme Court decision forces us to confront uncomfortable realities about technology, youth vulnerability, and the boundaries of criminal law in the digital age. It convicted a 24-year-old man for child pornography after he convinced his 14-year-old girlfriend to send him explicit photos through Facebook Messenger. What makes this case significant isn't just the conviction, it's what the Supreme Court said about privacy in the digital age, about consent when minors are involved, and about how laws are struggling to keep pace with how relationship and exploitation now happen online. Let's break this down. Section 1. What is this case about? At its core, this case is about the collision between three things: modern technology, teenage sexuality, and criminal law. Christian Cadajas, a 24-year-old canteen worker, met the victim, who will call AAA to protect her identity as required by law, is a 14-year-old girl. They began a relationship that existed largely online through Facebook Messenger. During their exchanges, Cadajas repeatedly asked AAA to send him photographs of her breast and vagina. She did. Her mother discovered these messages, and Cadajas was charged with child pornography under Republic Act 10175, the Cybercrime Prevention Act, in relationship to the Anti-Child Pornography Act. But this case became about how much more than that. It raised questions that makes us uncomfortable. What happens to privacy when evidence is obtained by a parent and not by a police? Can a teenage relationship ever justify sexual content? When does persuasion become coercion? And perhaps most importantly, in the age of social media, where teenagers are navigating sexuality largely unsupervised, how do we protect them without understanding what protection actually means? Section 2. The facts. Let me walk you through what actually happened because the details matter. So, Christian Cadajas and AAA met in 2016. She was 14. He was 24, a full decade older. According to the records, AAA developed a crush on Cadajas and pursued him. They connected on Facebook Messenger. He courted her for two weeks, and they became what they called sweethearts. Her mother, Triple B, discovered the relationship when Triple A would borrow her cell phone and forget to log out of Facebook. The mother disapproved. Triple A was too young. She confronted Cadajas and told him to stay away, but they ignored her. Then, in November 2016, things escalated. The mother read their conversation, and Cadajas was telling Triple A, "Sige, hubad na," or in English, "Go ahead, get naked." He asked her to remove her underwear, to take photos, to spread her legs closer to the camera so he could see her vagina. And here's what critical. Triple A testified that she felt pressured, and she said Cadajas kept saying please, that he wouldn't stop, and that she felt compelled to send the photos because of his persistent requests. When Triple A's mother forced her to open Cadajas' Facebook account to retrieve the message, the evidence was there. Two criminal cases were filed, one for violation of the Special Protection of Children Against Abuse Act and for child pornography. The trial court acquitted him of the first charge, reasoning that Cadajas was a city lass who was no longer innocent of the ways of the world. A disturbing piece of reasoning we'll return to, but he was convicted of child pornography. Section 3, the issues. The Supreme Court had to resolve four major issues, but I want to focus on three that matter the most. First, privacy. Cadas argued that the photos were taken from his Facebook Messenger account without his consent, that this violated his constitutional right to privacy, making them inadmissible as evidence. Should a private message, even in incriminating ones, be protected from use in court when obtained by civilian, not the state? Second, what actually constitutes child pornography? Cadas claimed his action didn't fall under the law. He argued that child pornography requires production for distribution or profit, that he was just a boyfriend asking his girlfriend for private photos. So, does the law criminalize private exchange between people in relationship or only commercial exploitation? Third, the sweetheart defense. This is the argument that's been used and abused in countless cases. Cadas claimed he and Triple A were in consensual relationship, that she willingly sent the photos, and that their age difference and her willingness should matter. The question, can romantic relationship even justify sexual content when one party is a child? Section 4, the Supreme Court's ruling. The Supreme Court upheld the conviction, but what's fascinating is how they reasoned through each issue. On privacy, the court said Cadajas' constitutional right to privacy wasn't violated because the Bill of Rights protects citizens from government intrusion, not from other private individuals. Triple A's mother wasn't a state agent. She was a parent protecting her child. Moreover, Cadajas had given Triple A his password. He voluntarily limited his own expectation of privacy by allowing her access to his account. And critically, he even objected to the evidence during trial. By the time he raised it on appeal, it was too late. The court called it waiver. On what constitutes child pornography? The court rejected his narrow interpretation completely. They examined the legislative history of the Anti-Child Pornography Act and found that Congress intentionally criminalized even mere possession for personal use, not just commercial distribution. The laws proposed is to protect children from being sexually objectified. Period. Whether Cadajas planned to sell the photos or keep them for himself is irrelevant. By inducing a minor to create a sexually explicit image of herself, he committed child pornography. On the sweetheart defense, this is where the court's language became pointed. Justice Lopez wrote that consent is immaterial when the victim is persuaded, coerced, or induced. Triple A was 14. Cadajas was 24. That 10-year gap placed him in position of power. The court noted that teenagers are curious about their sexuality, but are not capable of giving rational consent to engage in sexual activity without proper guidance. They are vulnerable to manipulation. And here's the critical part. The court said we cannot allow the sweetheart defense in child pornography because Romantic relationships are precisely the context where children are most easily exploited. The court reclassified the crime as mala inse, inherently wrong, not merely mala prohibita, wrongly only because prohibited by law. And they increased the penalty from the Court of Appeals 14 to 18 years to reclusion perpetua, life imprisonment. Section 5, takeaways. So, what do we learn from this? I have 5 takeaways to go beyond the black letter law. First, digital privacy is conditional, not abuse. Many of us assume our private message are protected, but privacy depends on context, who has access, what's at stake, whether you're dealing with the government or private individuals. When you share your password, you share your privacy. When evidence involves harm to others, especially children, the calculus changes. Second, the law recognizes that power imbalance make consent complicated. This case matter because it refused to accept surface level consent. A 14-year-old saying yes to a 24-year-old isn't the same as two adults making free choices. Age, maturity, experience, social position, these all affect whether consent is real or coerced. The law is starting to grapple with that. Third, technology has created a new form of harm that old categories don't capture. Child pornography used to mean commercial production and distribution. Now it includes the teenager being pressured to take a photo on her phone and send it via Messenger. The harm isn't less real because there's no camera crew or profit motive. The exploitation is the point. Fourth, parental intervention in the digital lives of children is not just permitted, it may be necessary. Some might find it troubling that a mother accessed her daughter's messages, but the court saw this as a parent exercising her duty to protect her child. In a world where so much teenagers lives and happens in spaces parents can physically supervise them, this case suggests that monitoring isn't intrusion, it is protection. But here's the fifth takeaway, and it's the one that troubles me the most. The trial court acquitted Cadajas of violating the Special Protection of Child Against Abuse Act because they found AAA was a Cadajas, no longer innocent of the ways of the world, and that she was not affected by what happened. Think about that. A 14-year-old girl is deemed too wrongly to deserve protection under law specifically designed to protect children. This reasoning, which the Supreme Court didn't explicitly reject it in full, reflects a danger assumption that some children, by virtue of where they live or how they present themselves, are less deserving of the law's protection. It suggests that innocence, not age, is what triggers legal safeguards. That's very wrong. And it's a reminder that even in progressive decision, troubling biases persist. Cadajas versus People forces us to recon with how the law adapts or fails to adapt to the realities of how young people live, love, and harm today. It's a case about technology, yes, but more deeply, it's about power, vulnerability, and the state's role as protector when the adults in the room fail to act like adults. Thank you.